Welcome to this ILTA podcast. I'm Chris Acosta, Director of eDiscovery Resources at Morrison Foerster, and I'm your moderator for today's session on Reading Between the Lines, How Data Maps Decode eDiscovery. In this digital era, with an ever-expanding array of data sources in eDiscovery, understanding and leveraging data maps is increasingly vital. We have two esteemed experts in the field of eDiscovery joining us today. First is Andy Kim, eDiscovery Counsel at Munger, Olson, and we are also joined by Tyler Crabtree, who's the eDiscovery Litigation Technology Manager at the Los Angeles City Attorney's Office. Would you like to give a brief introduction? We'll start with Andy first.
Hey everyone, thanks for having me. My name's Andy Kim. I'm eDiscovery Counsel in Munger, and Olson San Francisco office, and I help manage and consult on eDiscovery issues for the firm.
Thanks, Chris, for the introduction. My name is Tyler Crabtree. I'm the eDiscovery and Litigation Technology Manager with the Los Angeles City Attorney's Office. So I support our attorneys and staff with their eDiscovery needs, from litigation and to investigations and public records act requests.
Great. With our panelists introduced, let's explore the role and evolution of data maps in eDiscovery. First question. So what are the most significant benefits of using data maps from both a legal and practical perspective? Andy, would you like to take this one?
Yeah, thanks, Chris. So I think with data maps, there are not only a ton of significant benefits to them, but I really just think these days they're absolutely essential. They're essential because you need to utilize them to properly prepare for litigation, to help evaluate the risks in your specific matter and for the client, and overall just develop a thorough plan on how you're going to be addressing the data in your respective matter. So just going back real quick, data maps really are just an industry term for the roadmap for your data. Just getting a thorough outline of all the possible custodians and data sources in your respective matter. From a legal perspective, these are absolutely necessary because, as you know, in federal matters, you may be required to provide disclosures of all the custodians and data sources in your matter. But also with the advent of SB 235 in California as of January 1st, you're absolutely required to provide the custodians and data sources upon a demand from a party within 60 days. So we know it's not just recommended to have these, but it's absolutely going to be necessary. And from a practical perspective, we know that discovery is the most expensive part of litigation. And not having a plan can really create risks and also add significant costs to your respective matter. And we know that clients and opposing counsel are more and more knowledgeable about eDiscovery these days. So not being prepared with a proper data map only invites more oversight and scrutiny into the way you're managing that process. So overall, I think data maps provide a ton of value, but they really aren't optional anymore. I think they're just expected.
I think Andy hit all the major points. I would just add that, from a practical perspective, data mapping, it's not the same as like an IT map. I've met with clients before when, we're going to discuss data mapping and, I'll get a spreadsheet from them or like a nice little graphic that lists out where all their servers are. And yeah, we've already got that done. So I think it's also important just to understand that it's like a living document that we're going to be working in. You need to track not only where the data is, but who has access to that data, the retention policies of that data. So, again, it's not an IT map. It's a data map of everything within the organization. And they're great with helping with identifying key custodians. So all of that leads you down the path of making sure you're finding every nook and cranny for where data is residing.
Great. Thank you, guys. Second question, how can data maps improve the efficiency and cost effectiveness of eDiscovery projects?
Yeah, I think that's a really good question because by their very nature, data maps are designed to make the discovery, which is an extremely expensive component or part of the matter, much more efficient and cost effective. So what I think there's a lot of things outside counsel can do to make sure that they are proactively thinking about these things when managing a case. I think the first thing outside counsel can do is making sure that they're having really thoughtful and carefully tailored responsive and objections, because ever since the 2015 amendments to Rule 34, we know that your objections need to be tailored and specific. General and boilerplate objections just aren't going to cut it, and they're going to be looked poorly upon. So having those really well-defined R&Os are really going to help you tailor the scope of your data set, and thus helping your client to save on costs downstream. I think another thing clients can do to help, or I think outside counsel can do to help improve the efficiency and cost effectiveness of projects, is really analyze the company's policies regarding data. So do they have a well-drafted policy for data retention, BYOD, reasonable use? These are going to be really important for you to understand how the client manages those data sources, and can help guide you on how to handle each of them when you're going through discovery. And I think on top of that, another thing outside counsel can really do is making sure their data map is extremely well thought out. I think there's that age-old adage of measure twice, cut once, right? That when you are handling, is you don't want to have to go back to the well over and over and over again to try to figure things out. So I think it's really important from the onset that counsel is looking at this and pulling in all potential stakeholders. That's IT, in-house counsel, all the respective managers, to clearly discuss and make sure you're synthesizing the information of all possible data sources, all possible custodians, and pulling this together into a concise format so everyone can be on the same page about what you're doing with what data sources, so that you can streamline this process downstream and not have to go back to the well over and over and over again.
And Tyler, what about you? How have you seen this?
Yeah, I mean, I think again, Andy really nailed it. The big thing is that, it allows your collection efforts to be more targeted. So you're going to minimize unnecessary data collection, which is going to lead to cost savings. I've heard data mapping described kind of as like doing your meal planning or getting your grocery list together. So I've used this to kind of explain it to attorneys. So when you go to the store and you don't have your meal plan for the week or your grocery list, you start going down the aisle and you start grabbing all the things that look good. So you're going to be collecting all this unnecessary foodstuffs. Go home, you put everything into your fridge and you realize, oh, I already had a dozen eggs and I just bought another dozen eggs. What I really needed was butter and I forgot the butter, and now you got to run back again. So it's kind of like Andy's saying, you don't want to have to go back to the well. The data map is going to be your meal plan, your grocery list for your case, so you can make sure that you're targeted in what you're collecting, so that when you're working on your matter, you have what you need and you're not constantly going back to the client, who does have other things to do. I mean, their IT staff is already stretched. They've got full-time jobs. A lot of times litigation is adding extra work on top of what they're already doing. So they don't have time necessarily to, constantly be going back and doing pulls for you if there are things that you're missing. So frustrated clients is not a good thing to have.
Yeah, I actually like that analogy. I'm going to have to use that sometime. Next question. How have recent technological advances influenced the way data maps are created and used in the eDiscovery process? Do you have any examples where the technology has significantly improved or created challenges? We'll start with you, Tyler.
Yeah, I'd say in terms of like recent advancements in data mapping, it's made everything more complicated. So I mean, gone are the days where you could just simply identify a custodian and, we're just pulling emails and there might be like one file server location that you're pulling records down from. I think, with the one of the biggest factors recently that I've encountered is especially the pandemic. So we've had organizations that had to pivot really quickly with a workforce that's working remotely. So they were grabbing tools and anything that they could do to keep the business and the lights on and things running. And a lot of times that didn't necessarily comport with any kind of data retention policies that they may have had, because they were implementing these applications and programs, group chats on the fly. So, it definitely added complication in terms of, okay, we've got all of these new tools. where are they now that we've got this in place? So there's kind of been like this collective, deep breath that everyone's taken now that the pandemic has kind of resolved itself a little bit. And now people are kind of looking back going, wow, what did we do? And it's kind of like this cleanup of going through and identifying these sources, coming up with retention policies and plans. And I would say that a data map, it's a living document. So you just have to make sure that throughout the course of your case, you're constantly going back, reevaluating, and making sure you're incorporating any new technology or applications that your client is using. Because litigation goes on for years, and the client's not going to stop, implementing new policies, adopting new practices. So you just need to make sure that you're staying on top of their current trends as well.
Great. Andy, do you have anything to add to this?
Yeah, I think Tyler makes a really good point that it's a living document. So we all, as professionals in this industry, need to make sure that we are being dynamic and constantly adjusting for technologies as they change. From my perspective, the way technology really plays with data mapping is it's a double-edged sword, right? Technology has created a ton of solutions to help address a lot of the major problems we have in eDiscovery, but technology is also creating so many more challenges on a daily basis that we're always forced to keep up. And I think, for example, when you look at all the solutions that technology has created for eDiscovery, look at Purview. It's a lot easier to implement litigation holds and export data faster. Slack's eDiscovery platform has evolved. Relativity Legal Hold is streamlining the litigation hold process, which we all know has traditionally been very cumbersome. So there's a lot of technologies that are really providing a lot of new solutions out there that teams can implement quickly and efficiently to help clients save costs. But legal, by its very nature, is forced to stay behind because we are very much reactive to the way litigation happens and how quickly technology comes about. And so, for example, you can see things like mobile data collections, right? While we have a lot of tools to help us address the major problems with mobile data, there's so many new applications coming out that it's very hard to keep up, right? There's so many different types of mobile messaging platforms that each one of them have to be treated differently and uniquely. And we are constantly trying to figure out how to address these as we see greater use by custodians. Another example, structured data, because by its very nature, it's tailored to a specific institution and it's not very much the same across the board. So we have a lot of trouble on how to utilize that and how to streamline that process and standardize it across matters. And I think also another big component is ESI protocols, the document that controls how we produce documents in a specific matter. A lot of ESI protocols still primarily focus on email production, but we know that a lot of custodians these days are using various other platforms to communicate on a day-to-day. And so with that, from a legal perspective, we're constantly trying to update ESI protocols based on our data mapping and figure out how to best convey what we need to do for the specific matter. So my big takeaway on this, technology has provided tons of benefits for us, but is also creating new and more difficult challenges every day for us.
That's true. I think, one thing that Tyler mentioned about the use of the technology to help with a collaboration, especially during the pandemic. And I think in the spirit of collaboration, you think about it, how is data mapping which requires different collaboration between departments and stakeholders, how do you essentially encourage the stakeholders and these different departments to effectively collaborate on this initiative? Tyler, what do you think?
Yeah, so my experience has primarily been in the government space. So obviously working with the city, but also prior to that, I was with the California Attorney General's office. So we had a lot of experience working with various government departments. Some are incredibly large, some are very small. One of the big challenges is they're frequently, understaffed and underfunded. I mean, that's just kind of the way that government operations tend to go. So in terms of collaboration, one, you have to drive home the point that this is about cost savings, right? It's an upfront effort, yes, but it's going to save you money in the long run. So that is always something that clients want to hear. Like, how are we going to save them money? So by doing this data mapping, you are efficiently collecting, getting things ready for review. You're saving on review costs because you have less data to look at. You can approach them with different types of tools, like early case assessment tools, things like that. But I think it's a big collaborative effort. And so I think you need to understand kind of the position that the client is. What are their pain points? What are they struggling with? And having that open mind and being conscious of that, I think, goes a long way in fostering collaboration. And I think you also just need to be prepared to be patient. We deal with this all the time. For a lot of clients and their staff, like, litigation is new to them. It can be scary. You're going in there saying, hey, I'm going to collect all your data and we're going to review it. I mean, everyone gives them a little bit of pause. So I think being aware of custodian anxiety and being open to them and listening, and just being prepared to educate them on the process, to be patient, to walk them through, let them know what the steps are going to be, can go in a long way in making them feel more comfortable and kind of fosters that collaborative effort.
Great, thanks. And Andy, from your perspective as outside counsel, what do you see?
Yeah, I think Tyler raised a lot of really good points on how to be successful in that kind of situation. And from my perspective as outside counsel, you really need to be mindful of your client and what their needs are, but also balancing that with what the needs of your specific case are as well. So some of the things that I think about when trying to push these initiatives forward is, like, one thing is be proactive, right? The client hired you to handle this matter. So when you're working on this, set the agenda and timeline early on, check in regularly. Clients are going to notice when you're sending emails that contain things like, hey, sorry about this rush, or sorry for this last minute thing. They're going to take notice of those things. So being proactive and making sure you're actively and proactively managing the case is going to be really important. I think another thing is being empathetic. Like Tyler mentioned, a lot of these people that you're working with in terms of your data map and your respective case, they have their regular jobs. They are often working on a million other things. So because of this, you really need to come to the table understanding that and be respectful of their time and their roles, and making sure that you're communicating very clearly, concise, and thoughtfully. And when you're approaching them, I also think it's really important to have a well-defined plan. You're going to need to approach these step by step. So when you're conducting your custodian interviews or drafting your data map, it's going to be really important for you to have a plan on how you're attacking preservation and collection, and that making sure you're synthesizing this information for everyone on the team. This is going to really ensure that you have strategic goals and that they're being executed, and that you're really mitigating the risks in the case, which you're really there for. And I think one more point is you got to be transparent, right? You're in this together with your client, and so I think it's really important for you to share your work product, get their feedback, because data maps are incredibly complex. You can be interviewing dozens and dozens of people and may not have the full picture or the full story. And so sharing your work product with in-house counsel, someone who is in that company, is going to be really important. Sharing that information with experts who might have additional insights on how to tackle certain problems are going to be really important. So be transparent with all the people that you're collaborating with, because it's only going to help you in the end.
Great, thank you. Last question. So, what future trends do you anticipate in the field of electronic discovery, and how data mapping plays a part in that? Start with you, Andy.
Yeah, I think from my perspective, there's a few things here that I'm starting to see as trends. And from my experience on matters personally, I'm noticing clients and opposing counsel are more and more knowledgeable and more sophisticated about discovery. So I think how how you would have considered being prepared a few years ago is not really sufficient anymore. I think you really need to be informed and seeking experts often to help with all the different data types that are coming in. And that goes to part of your ethical duties of being competent on your matter. So you need to be more prepared for all the various types of data these days. It's not just email and text messages anymore. There's a lot of different data types, and you need to be prepared for all of them. I also see in various case law coming through over the recent years that courts are actively addressing these issues that are popping up in eDiscovery, mainly issues around competency, right? I think that they're not going to be easy on counsel who's just delegating these tasks and not providing any oversight. I think that poses great risks and concerns for the case, and attorneys on that matter need to be very thoughtful about this and need to be prepared. And I think the last point on this that I think is really interesting and I'm personally super excited about is the advent of generative AI in the e-discovery industry. I know that the industry has been using analytics like technology assisted review for many years. It's a very standard workflow, widely accepted. But I also see that the industry doesn't wholeheartedly adopt it all the time. And I think it'll be really interesting to see how the industry approaches generative AI, because from the demos that I've seen, there's an immense amount of promise. I think it could provide lots of efficiency and cost savings for clients, but we'll see how it gets adopted on cases. We'll see how the case law addresses it, and we'll see how it gets implemented in various ESI protocols.
Great. Thank you, Andy. And Tyler, what about you? What are some future trends that you anticipate?
Yeah, I mean, I think Andy's right. When it comes to generative AI, I think, we're going to see a lot of things coming out over the next year or two. I've seen some demos, again, like Andy said, it looks really promising. It's going to be interesting. I look forward to kind of explaining it to the attorneys when they go to use it. But yeah, I think, AI is really the big buzzword right now in the industry, especially ChatGPT. We're always seeing things in the news about it. Some things good, some things not so good. So it'll be interesting. And I think the other one that I would touch on is, over the last few years, we've seen a lot come out in terms of privacy. So I think there's going to be a lot more consideration that's going to be needed when you're doing your data maps into how are we complying with any privacy laws or any restrictions that we may have. Different sets of data are going to have different restrictions. So it's going to be important to talk to the clients about that, especially if they're in a niche industry. Are there any special requirements or any types of unique PII data that they're housing that we need to identify that needs to be, can't leave the certain geographic location or things like that. So I think privacy is also constantly evolving. So that's going to be a big area as well to look at, I think.
Great. Thank you, Tyler and Andy, for your invaluable insights and expertise in today's discussion. And to our audience, thank you for tuning in to the ILTA Technology Podcast. We hope you found the session informative and thought-provoking. And goodbye, everyone. Thank you.
Thanks so much.